Now, you know, people talk about making a will. I mean, I've not mentioned it yet this morning, but and talk about having a will. Sometimes people will mention these sort of things to you, but unless you have great wealth, lots of assets and a complicated life, do you actually need one? Or is it something we should really all be thinking about? So to guide us through and answer our questions, please welcome Gemma Brooks from Cygnet Law. Hello to you, Gemma.
Good morning, Julie.
I knew I'd get a word out there at some point. It's the nervousness of working around a solicitor, I think that's what it is. Now, Gemma, what exactly is a will?
Well, it's a legal document that confirms where someone's estate should go when they pass away. So who should inherit their estate, who should be responsible for administering and dealing with their affairs. And there are other things that people don't obviously think about when making a will that are often included, such as appointing guardians in the event that somebody has minor young children and they pass away, and who they would like to care for their children. Funeral instructions going there. So it's a legal document that takes care of all those things when someone passes away.
Now, I suppose people might say, well, you know, I'm married to Arthur, so whatever's Arthur's is mine, whatever's mine is Arthur's. Is it as straightforward as that?
Not always, no. If somebody passes away without a will, then the intestacy rules would apply. If somebody's married, then unless they do have great wealth, the majority of their estate will go to their spouse. It's often more of an issue when people are cohabiting and in long-term relationships, but they're unmarried. People don't often realise that if they pass away without a will and they are not married to their partner, who often they may have been with for many years, their partner would not inherit their estate. And that's something that people don't often realise. So for people living in that situation, then it is extremely important that they make a will and provide for the partner.
I'm glad you said that. I mean, genuinely, because I think this is something I only discovered a couple of years ago, because I only live with my partner. We're not married. Yeah. And I always say that. I say, well, you know, if anything happens to you, I'm scuppered. Can that actually happen, I could be turfed out the house?
It does happen. I mean, particularly if the house is in the person's sole name who's passed away, then the surviving partner doesn't have any automatic right to inherit from the estate at all.
I shall copy this link and I shall send it to the other half, just as a little reminder, just so you know. Now, what can you include in a will? Because obviously when you've taught there, you've said things like the children and your funeral, which you imagine, right, that's really serious. You know, when your kids, you've got to take them into account, that's fine. But how intricate can a will be?
Well, as much as the person wants it to be, really. Some people go into a lot of detail regarding personal possessions, things that have been passed down generations that they want to ensure go to their intended beneficiaries. People often go into a lot of detail about occupancy of a property, so not always who should inherit it, but if, for example, somebody wanted their children to ultimately inherit their property, they might want to give their partner a right to live there for a period of time. Things like that are often included in wills. It's not something that people always think about, but it's things that we guide them through when they come in, and we ask a lot of questions about their family dynamics and their relationships, and that allows us to be able to advise them of things that they might not necessarily have thought about.
Now, the reason I'm mentioning wills particularly, I think, is because people talk about having wills, but I bet people assume that the only reason you should ever make a will is if you have property or you have a reasonable amount of wealth. Now, am I assuming wrongly on that?
Yes, I think you are. I think people doing a will and making a will gives you certainty that you know not only who's going to inherit from your estate, but who's going to be responsible for dealing with your affairs when you've passed away. So for people who think, well, I don't own a property and I don't have huge wealth, I don't necessarily need one, it does give peace of mind and reassurance that you have named somebody as an executor, somebody who's going to deal with your affairs, and you know who is going to inherit. And for people who have particular wishes I've mentioned about funerals, about just distribution of their personal belongings, who they want to get them, if they want to leave anything to charity, if they have young children and they want to ensure that should anything happen to them, they would appoint somebody to be a guardian. All of these things are important and are as important as people, in my opinion, who have huge wealth and who, the obvious people who you would expect would make a will. I think those issues are just as important.
So, for an example, I don't have a house, but I do have a car. And on that basis, I could stipulate in a will, I want the car to, assuming it's still working by that point, that I would leave that car to a particular person.
Absolutely, yes. Yeah.
Now, you mentioned there about executor. I have been asked by somebody to be an executor of a will. I don't really know what that's involved because it was a relative, because he is a relative. Of course, I've said, well, yes, I am trustworthy. You can take me on board, that's fine. But what is actually involved in that?
The responsibility of an executor is to administer the estate, and by that I mean make sure what is in the will happens. So make sure the intended beneficiaries get what they have been gifted, ensure that funeral is conducted in a way that the person who made the will may have wanted it to be, and just be responsible for dealing with those affairs. If it is a more complicated estate, if there's a property, if there's assets such as investments or shares, things like that, then the executor is responsible for dealing with those assets as well, and just ensuring that the estate is administered as it should be.
Now, there may be people who don't really have any family. They're generally on their own, but they do have things that they would like to leave somewhere or to charity or what have you. How do they find an executor?
They kind of appoint friends, neighbours, or often we have clients wanting to appoint our firm to be executors, so professional executors. So we're quite often appointed in that capacity to administer an estate. Sometimes people who do have family and friends, but for whatever reason those relationships are difficult, they would prefer somebody neutral, and they say, well, could you do it? And of course we can.
Is that something that you charge for? Is that a chargeable service to be an executor?
At the point that we administer the estate, not at the time of making the will, but at the time, if we have to be engaged in of administering the estate, then there would be professional charges at that point. But what we often find is we get instructed to administer estates in any event by executors who aren't solicitors and work in the practice. It's family and friends who say, this is a little bit overwhelming, could you help? So we're engaged in any event, and it's not any more expensive if we are the executor.
Right, so let's say, would you say generally you should have a will regardless of your sort of personal sort of things, your wealth, what have you?
I would, yes. I just think it gives you certainty that you know who is administering your estate and where your estate will go when you pass away.
Is it like I've heard that, families can really have fallouts when there's no will in place?
Sadly, yeah, that does happen. And it's not pleasant for anyone involved in that situation. Someone's passed away and family are in dispute about what should happen. And I'm sure the person would have, that the last thing they would have wanted. So I think it's extremely important that people have that in place, and it avoids that, certainly.
Now, I know you've got to be very mindful about after the person passes and you've got that will. So, but can somebody actually sit down with their own family? So while they're actually living, they can discuss, this is what I want, this is what I want to do? Or is this very much a private thing?
People do. They often come in and say, clients, I've discussed this with my son and my daughter, and they're happy to be executor, or they know what I'm doing with my estate. And people, regularly discuss it with the family, and I think it's sensible, really, so the family know what's going to happen. But yes, it's something that people bring family members in with them sometimes and say, would you just explain to my son or my daughter, or whatever it may be.
Now, if somebody is an executor, does that mean they cannot be included as a recipient of anything in the will?
No, it doesn't at all, no. It's often the same people. a situation, for example, a couple who have children may leave everything to one another, appoint each other as their executors, and should that fail for any reason, appoint their children as their replacement executors, and everything then to their children. That's quite a common thing for people to do, and it's the same people named as executors and the beneficiaries.
Now, what if, as a couple, you decide to... Can you have a joint will?
It's not. It's two separate documents. What it is, it's like a mirror. They mirror each other, like in the example I've just given. But it's not joint in the sense that it's one document. It has to be two separate documents.
So if one dies first, the other will comes into play, sort of thing.
Yes. Yeah, that's right.
Well, what we'll do is we'll stop there. We'll take a break because, it's a lot to think on, a lot to think about. When we come back, let's get down to the process of how you actually get somebody through that will-making process.
Mid-mornings on Zetland FM.
Now, Gemma Brooks is with us from Cygnet Law. We're talking about making a will. Now, like you say, I mean, some may say, well, of course you're going to say everybody should have a will. You're a solicitor, that's what you do. But there is a lot of protection, in a way, for you, your family and your assets, isn't it?
There is, absolutely, yeah.
Right, so let's imagine... actually, let's just go back, because you have been running a campaign with us over the whole of January about people making wills. How did that go?
We have. It went really, really well. It was a campaign where we prepared clients' wills free of charge if they were to consider either leaving a charitable legacy in the will or make a donation to Redcar and Cleveland Mind. It went so really, really well. And the last count, I think we'd had 83 clients take up the offer. So.
Wow, that's terrific. And I mean, that's a really lovely thing for you to do. Is this something you do on a regular basis?
It's something we have done in the past, and I think we thought it was important to support, this time, a local charity. It's a national campaign that I think a lot of solicitors firms engage in, but to help a charity that's in Redcar, where we're based, was really, really good.
Now, if somebody's in any way tempted and thinks, well, there are certain things like, I've got jewellery I'd like that to go to, and I've got a few bob I'd like to go to, and they would like to sit down and do that process. What is the process like? What do you do?
Well, they'd come in to see me for an initial appointment, and I would, like I've already mentioned this morning, speak to them about their own circumstances. Before I go into what we're putting in the will, I speak to them about their family and get an idea of what it may be that they would like in the wills. And then I always ask, do you have any idea? Do you know what it is you want? And then I'm led by them. Some clients come in with everything. They know everything they want to put in the will, and that's great. But other clients say, well, I've thought about this, but do you think this would work? What about this? I don't really want to do this, but I don't know what my other options are. So we guide them through that and take full instructions at that initial appointment. Sometimes clients go away thinking about certain options that I may have put to them. They get back to me and let me know, and then they come in for a second appointment and sign the wills and approve them at that appointment. I witness them and one of my colleagues with the two witnesses in the office, and then we either store them for them free of charge if they would like us to and provide a copy, or alternatively some clients say, well, I've got a safe at home, I'd like to take it home, and again, that's absolutely fine.
Now, of course, it can be one of those things, and I often use this as description. If you were to give somebody an unlimited amount of money and say, go to the sweet shop, do what you like, it's quite, I don't know where to start. Sometimes you kind of need those boundaries in place to help you along your path. Do you know what I mean?
Yeah.
So if you can kind of do anything with a will, where do you start? I mean, really, if you think, I want a will, I just don't know what to do with it, can you help there?
Absolutely. The first thing that I always ask is about executors. They're the people that make sure what's in the will happens. They'll start by asking who the people have in mind to appoint as executors. The next thing we speak about is if they have any wishes regarding funeral arrangements that they would like to put in the wills, and in relation to guardian appointments if they have young children. Then we come on to what they would like to do with their estate. And some clients know from the outset that whatever they have, doesn't matter what it is, it's all to go to whoever they have in mind. Some clients will say, well, I'm not really sure, and we break it down. We say, well, what is it that you have at this point in time? Would you like, and we look look at either percentages or, say, for example, leaving a property to somebody, any money in the bank to somebody else, and do it like that so to ensure that they know that it's not everything going to that one particular person if they have other people that they'd like to benefit and inherit from their estates.
And of course, we're all human beings. We all have barneys. We all have fallouts. Yes. If you were to make a will, that is not absolutely set in stone forever.
Absolutely not. No, you can change your will at any point in time whilst you're fit and well enough to do it. You can change your will. We have clients who've done a couple of wills in the past with us, and the circumstances have changed, and they say, well, I'd like to update it and make a new will, and that's absolutely fine.
That's interesting you should say that. While you're fit and well to do that, what if you were getting towards the end of your life? You're not necessarily fit and well, but you haven't got a will in place. How do you get covered with something like that?
When we're drafting a will for somebody, we have to be satisfied to protect the client, that the client's not under any pressure or duress, and we always see the client on their own at some point in time. Clients sometimes bring the children because they say, oh, can you explain this to them? Or sometimes if we go to a home visit, because clients can't get into the office for whatever reason, we go and visit them at home, and the family will be there, but at some point through the process we always see them on their own. We have to be satisfied that there's no pressure or duress there. The second thing we have to be satisfied of is that the client has capacity to be able to give us those instructions and fully understand the nature of those instructions that they are giving. If we as solicitors have any doubt about that, with the consent of the client, we would contact their GP, would be the first thing we would do. And usually it's resolved and it's fine, because we're not there to assess things like that ultimately.
It is a funny old thing, though, isn't it, really? Because some people can be, things like dementia and stuff like that. I suppose the key is to kind of get, if you're aware of that, to get in early, I'm guessing, yeah?
Yeah. I have a lot of clients that come in and see me and say that they've sadly had a diagnosis of dementia, but they're well enough to give their instructions to me. They clearly understand, but I think that diagnosis may have prompted them to think, I want to get my affairs in order now. And we have a lot of clients that come in and tell us just that.
Oh, that's awful, isn't it? But I suppose, taking control of your life so that people are not having the bickering and the barneying afterwards is really beneficial. So how long is this process then, from that first appointment with you?
Well, that's client-led, really. I endeavour to get the letter out to a client within a week of them coming in to see me, to say that your will's been prepared, and invite them to come in for an appointment to approve the original. Some clients will say, I'm going on holiday next week, or could you do it by the end of the week? Absolutely, we do that. If in situations, sadly, some people might be quite ill and want it doing quickly for that reason, and again, we do that straight away if that's the case. Some clients, it'll go out of their mind and they'll come back 3 weeks later to sign, and it's led by them, really.
So am I generally only going to beat you twice then for this?
Yes, twice, unless sometimes clients will come in and say, well, I've thought about it, and sometimes, it doesn't happen very often, but they've completely changed their minds about what they want to do at their second appointment, or changed quite a lot of the will. So they'll come in and see me again and say, actually, I've been thinking and I want to do this. And then they come in for a third time to get the document signed.
I can imagine that, actually, because once you've had all the questions and the discussions, that's when you tend to have those thoughts go through, going, oh, is that the right thing? Should I have done this? Should I? And I suppose, that's when that comes into play. Now, of course, the question people will always want to know the answer to is, how costly is this?
For us to do a simple will for a client, our fees are £75 plus VAT, so it's £90. For a couple, we do the mirror wills that I mentioned earlier this morning, it's £130 plus VAT.
And how early would you recommend people think about this?
Straight away, really. It's never too early to think about it. I do have quite a lot of young clients that come in who have perhaps just got married, they've just had young children, they've just bought a house, and they want to get a will in place. And we do have quite a lot of people associate it with older people, something they do. It's not the case at all. We have young people who do wills quite regularly.
I'm guessing sometimes it's a life-changing event that kind of triggers that process.
Yes,
is it?
it is. You often find that they've just got married or bought a house is another example, or had children.
Anything else that you really need to mention before I let you go?
Not really, no. Just if anyone's been listening this morning and they have any questions, just to contact myself at Cygnet Law, and I'll be happy to assist if I can.
Lovely. Gemma Brooks, lovely to meet you finally, because we've talked on the phone a few times.
We have.
So really nice to meet you in person. Thank you for coming in.
Thank you.